For cases that were ready for trial on January 1st of 2020, did the new criminal justice reform make them unready? To find out, you have to read People versus King, but it's 20 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus King. The citation for this case is 2024 New York Slip Opinion 03322, published by the New York Court of Appeals on June 18th of 2024. The issue in this case is whether the newly passed speedy trial statute and discovery statute affect cases that were ready before the effective date of those amendments. To understand and appreciate the context of this case, obviously the important part to know is what speedy trial statute is. Under CPL, Criminal Procedure Law 3030, each kind of crime or offense has a certain amount of time before which the people must declare ready. So for certain felonies, it's 6 months. For misdemeanors, it's 90 days or 50 or 60 days, 15 days for some kind of offenses. But each kind of offense, depending on the criminal level, there's a certain timeline before which the people must declare ready and they must try the case. If it exceeds that statutory amount of time, the case is subject to dismissal. Before January 1st of 2020, CPL 3030 just required that the people have done everything that's required before they can try the case, and then they file a statement of readiness, and that stops the clock for 3030. But then the new discovery laws were passed, part of this criminal justice reform, which were effective as of January 1st of 2020. And the effectiveness of that statute basically said that before the prosecution can file a statement of readiness, they must also file a certificate of compliance with the new discovery statutes. So it linked readiness for trial with completion and certification that you've complied with the discovery statute. So as of January 1st of 2020, the people cannot file a statement of readiness, cannot stop the clock until they've done everything they're supposed to do pursuant to the rest of the discovery statutes. And they're not ready until they do that. Okay, so what are the facts in this case? The facts are that here, the defendant, Mr. King, was charged with attempted second-degree murder, second-degree assault, and other charges arising out of an incident where he threatened his children with a knife and stabbed his pregnant wife several times in her hands, feet, and chest. And this is all pre the new statute. In 2019, the defendant was indicted, and the people declared ready for trial with approximately 1 week left of that speedy trial clock. And that was before January 1st of 2020. On January 1st of 2020, the new discovery laws and speedy trial statute was effective, and went into effect. On January 27th of 2020, the case was now scheduled for trial, and on that day, the defense counsel moves to dismiss the indictment as a violation of speedy trial, saying the people failed to satisfy their obligations under speedy trial because they have not declared ready under the new 3030 requirements. The trial court denied that application, held the amendments did not apply to this case. The jury ultimately convicted the defendant of remaining counts, but acquitted him of the attempted murder. So he's convicted. He's convicted and he appeals. The appellate division reverses the conviction and dismisses the indictment, saying it did apply. The new amendments did apply. And it goes to the Court of Appeals. And here what we have is a sharply divided Court of Appeals. We have a majority, we have a concurrence, and we have a dissent. The majority, which is the holding in this case, the question is, are cases this is how they frame the case. They frame the question. Are cases that were already ready on January 1st of 2020, did they automatically become unready based upon the effectiveness of that new speedy trial statute? And they say, well, the answer to this question has to be, we have to look at the text of the statute. And because the language of the amendment to the statute does not, and this is the quote, because it does not expressly or by necessary implication require retroactive application, then we cannot conclude that the legislature intended the certificate of compliance requirement to apply in this matter. And therefore, the readiness, the case that was already ready, this King case was ready before January 1st of 2020, and it remained ready until it was on for trial on the 27th of January. Therefore, the conviction is not reversed. The concurrence by Judge Wilson, though, says, he answers differently. He says the answer is correct. The conviction is not reversed. But he reads this to say, was the case commenced before January 1st of 2020. He thinks that's the deciding factor. And because it was commenced before 2020, this does not even apply. The statute does not apply. But finally, we have a dissent by Judge Rivera, and she says, as of January 1st of 2020, the people were unready until and unless they filed a statement of readiness and certificate of compliance with discovery, and they didn't do that. So she would reverse the conviction. But once again, the majority here says that the conviction is not reversed and it does not apply because the people were unready and remained ready. The people were ready and remained ready up until the trial date on the 27th of January. And that's the case of People versus King. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.